Good morning, Your Honors. Annabelle Majeski on behalf of the Munsons. If it pleases the court, I'd like to reserve 5 minutes for rebuttal.
That's fine. Whenever you're ready, you may begin.
Thank you, Your Honor. We have 2 issues here, whether the expert affidavit was sufficient as to the standard of care for nurses. And then we have whether a leave to amend should have been given, even if the hospital was not had vicarious liability for the nursing staff, because Dr. Venkat's affidavit was not sufficient. We still have the issue of amendment should have been granted as to the direct negligence of the hospital itself, in that it did not conform with certified stroke center requirements. I think the confusion with whether Dr. Venkat could testify, give an opinion as to the standard of care for nursing staff, started off with the confusion as to whether NHH, which appeared on the chart, was a nurse. And it was taken to be that was a nurse because apparently nurses are the ones that usually perform this test.
I'm sorry to interrupt you right at the beginning, but I want to orient myself on a couple of things, and then it will help me follow the argument a little better. And you can, because I have some impressions, and you can correct me if they're wrong, and then I won't be laboring under a false impression throughout the argument. It seems to me that as you all framed your affidavit and your complaint, is you are approaching this as our client went to a stroke center and there is a stroke center standard of care, and everybody, whether they're a nurse or a doctor, whatever their position is, if they're in that arena, there is a standard of care for people in a stroke center. And what the hospital appears to me to be doing is they don't want to talk about stroke center standard of care. They want to break it down into individual components, nurses, emergency room physicians. So you need a nursing expert, an emergency room physician expert. That has nothing to do with strokes, just a more general, the more general arena of what goes on in an emergency room as opposed to a stroke center. Is that a fair view of how this has been set up?
Yes,
or
Your
am
Honor.
I under? Okay.
Yes, Your Honor.
So I'm not mistaken about that.
No.
Okay.
And that's
And
why.
can I add to frame the issue, because I did not hear you mention, and I'm going to call it Dr. Venkat, Dr. Venkat's ability or competence as an expert to testify as to Dr. Healy, an emergency physician. Are you abandoning that, or are you still arguing that she's qualified to do that?
No, Your Honor. I abandoned that right away. In the initial brief, I made it clear that, yes, according to the statutes, she is not qualified to testify as to an emergency room physician. The problem is at the trial level, the trial court was caught up in the fact that since she could not, that we had originally identified Dr. Healy as a nurse, then it was later came out that he was an emergency room physician, that since she was not qualified to testify against him as a nurse, because he had no nursing duties, and for sure she was not qualified to testify as to an emergency room physician because she is not an emergency room physician. And therefore, since she couldn't testify against Dr. Healy as a nurse, she couldn't testify against any nurses. And that's where things got kind of complicated. And all throughout the trial court's final judgment addresses the fact that, that we couldn't support a claim against the Dr. Healy emergency room physician, and therefore we couldn't support one against the nurses.
Okay, I'm sorry to interrupt, but his question and your answer has opened up another question for me.
Okay,
Okay, so you say she's not able to testify as an expert with respect to Dr. Healy as an emergency room physician. But how
Correct.
about with respect to Dr. Healy as a physician in a stroke center? Are you abandoning that as well?
no, Your Honor. We're saying that she's competent to testify as to the standard of care as to all medical personnel.
Including Dr. Healy,
If
including
he's-
him?
If he's working in the emergency
Well, he
room,
was. I mean, that's your allegation. Isn't he the one that initially saw her?
yes, now it turns out that he was. What I'm trying to say is that, was he there as an emergency room physician, or was he there as a physician that treats patients under a standard of care applicable to medical personnel at a certified stroke center?
And do we know that?
No, that's not been determined.
Let's assume that it's both. If you look at 766, which has to be strictly construed, I don't see a provision whereby it allows a pre-suit notice against an overall entity that specializes in certain medical care, such as stroke, cancer, or anything else. It's individualized. And what your pre-suit notice did was identify Dr. Pappas, the neurologist, who was on call. And it didn't notify the hospital of anybody else. I understand that there was some confusion and discovery as to whether or not the defendant disclosed the identity of other medical professionals. But I'm still looking back at 766, which we must strictly construe. So explain to me how you're using a stroke expert to provide pre-suit notice that qualifies under 766 against a stroke center when the statute itself doesn't seem to provide for that.
Well, the intent of 766, if you look at 766.203, the corroboration that the pre-suit corroboration is basically just to assure the defendant that some investigation has been done and this isn't a frivolous, out of joint suit. Our point is that we're hoping to reverse summary judgment as to the fact that that Dr. Venkat can give an opinion as to the nursing standard of care in a stroke center, that she is qualified to do that. As to whether Dr. Healy, her testifying against Dr. Healy as an emergency room physician, no, she cannot do that. 766. Let's see, which one is it?
Well, tell
102.
me how Dr. Venkat and her qualifications are comparable to that of, is it Dr. Holland or Dr. Hubbard? I can't remember.
I think it's Holland, Your Honor.
Okay, so Dr. Holland, who's an ER physician, he testified and implied about having, requisite experience about the nursing standards of care. Are they comparable or not? On Venkat and Holland.
Well, Dr. Holland was there to testify about Dr. Healy's standard of care for emergency physicians.
Yeah, but the
And
trial
also-
court also accepted his affidavit as to the nursing standard of care too, and rejected Dr. Venkat. I'm trying to figure out if the trial court rejected that because Dr. Venkat wasn't licensed under Florida law, which would be error, because clearly, if the health department in the state of Florida can discipline out-of-state physician experts, then that does not limit who can testify about nursing care. So that's not an issue. So help me out.
Well, I think I brought that up in my brief too, that why is Dr. Holland qualified to testify again about nurses when Dr. Venkat is not, when they both basically they're both physicians, other than the fact that maybe Dr. Holland was licensed under the trial court had emphasized the fact that Dr. Venkat was not licensed under 458, even though she does have an expert certificate. So that was one of the things that we said, just because she is from out of state, she does have a medical, a certificate that even though it says that she's only allowed to testify against physicians, it doesn't say nurses specifically. For that purpose, for the fact that she's allowed to testify against nurses, we rely on Morris v. Munoz, which is 252 Southern 3rd, 1143, Supreme Court of Florida, 2018. The same thing there, the defendants in that case argued the failure to qualify under 766 from the out-of-state expert. That expert was in Texas, and she had been practicing obstetrics and gynecology for 30 years, and they were challenging the fact that whether she had been practicing law within the last 3 months of giving her opinion. And the Supreme Court said that respect to the ability of medical experts to provide an opinion on the negligence of nurses and other support staff, which is a separate subsection of section 76102, covers expert testimony regarding the standard of care applicable to nurses. And they then held that Morris's expert, Dr. Thompson, stated in her sworn affidavit that she was board certified obstetrician, had practiced for 30 years at a large medical center, had a staff of, was a chief of staff at a small hospital, and had a number of hospital-wide peer review committees. And she was engaged full-time in patient care, and she was currently licensed to practice medicine and received a board certification. And the Supreme Court said, as to the trial court's finding that Dr. Thompson's affidavit failed to establish that she was qualified to provide a medical expert opinion regarding the standard of care for medical support staff, we conclude that the trial court again misconstrued the statute's requirement. Dr. Thompson swore in her affidavit that she was chief, and it reiterates her qualifications. And it says, we failed to understand how Dr. Thompson could have overseen, managed, and reviewed medical support staff without knowledge of the standard of care applicable to that support staff. And that's the same thing we have here. Dr. Venkat is, board certified in all of the aspects of stroke patients, and she supervises her medical staff, which includes nursing staff. And so she is giving her opinion as to the standard of care of a certified stroke center and the personnel, medical and otherwise, that works at that stroke center, that, what the duty of care is for all of those people in order to be, providing medical help to stroke patients. And so therefore, I do think that she should have been allowed, that it was error to say that she was not qualified to give an opinion on the nursing care. We do agree that she is not qualified to give an opinion as to Dr. Healy in his emergency room physician capacity. The other thing, excuse me, our next thing is that the trial court seemed to be annoyed that the motion for leave to amend came rather close to
4 days before the summary judgment.
right. And then
Right.
he characterizes it as an attempt to avoid summary judgment.
Well, yes, which you are allowed to do.
Correct. So that's why he seems to be very annoyed with the fact that, we're trying to avoid summary judgment, but
That's
motion
the
for leave-
point. That's the point. What are you supposed to sit back and do nothing? No, I hear you on that.
Yeah, that's what we're saying, that if he had that in mind and somehow it was error to file it 4 days beforehand. I did cite to you cases where they've done it even after the hearing, but before the
Right,
written opinion
right.
has come out, and it's okay.
Oh, I hate to interrupt, but you're at your time if you want to save 5 minutes.
All right, Your Honor, I just wanted to briefly say that, and I'll come back and in rebuttal, that it was error not to allow leave to amend because amendment was not futile as to the hospital itself, which did have a direct duty of care if it's holding itself as a certified stroke center. And Dr. Venkat's affidavit was certainly already timely as to the hospital, and therefore amendment was not futile as to them, even though it's Dr. Healy it was because the statute of limitations was gone.
Thank you.
May it please the court, Dinah Stein on
Morning.
behalf of, good, thank you, Your Honor. Morning. Dinah Stein on behalf of PP Transition or POMS of Pasadena. And
I want to ask you something before
Yes,
you
Your Honor.
even get started, because this is, and that's why I jumped on your colleague right out of the box. It's been on my mind. It seems to me, when I read her affidavit, that she has set out in the affidavit, the expert affidavit, that she is able to opine on the standard of care with respect to the various actors within doctors, nurses. You know, she understands the standard of care for them within this unique universe of stroke care, and that she has the qualifications to opine as to a nursing standard, a physician standard, you know, staff, and generally as to the hospital and what it should be doing if it's going to hold itself out as having a certified stroke center. As I read your argument, it's very focused on, she's not an emergency room physician. So I feel a disconnect between the two. Can you help me with that?
no, absolutely, Your Honor, because, and I agree. I think plaintiffs really dug their heels on this theory of a negligent stroke center. And that her affidavit, the first affidavit, if you read it carefully, it is directed to the standard of care for neurologists and a hospital stroke center. And that's, you know, the problem we have had with this is that the stroke center, there's no such entity, it wasn't sued, the hospital was sued, and there's no theory recognized in the statutes or Florida case law that says you can have one affidavit for somebody who's not even a hospital employee in a department and sweep in every other employee of the hospital, regardless of.
I'm sorry to interrupt again, but it seems to me there's a little overlap here between an affidavit that says I can do this versus whether ultimately they're, you know, they can establish a duty, and all, you know, the things you're talking about seem to me to go more to duty or breach, or can you hold this entity liable for the actions of this person, as opposed to whether this expert can opine.
And not at all. I mean, I understand Your Honor's point, and the point being that she can certainly opine as to a neurologist. There's no issue with that. Her affidavit did not, the original affidavit did not even mention any act that was potentially the negligence of a nurse, other than the mistaken issue with Dr. Healy, which, you know, that was on plaintiffs. I mean, they haven't raised that as an issue. That was, you know, they got the wrong person, but that's not a nurse. So there's nothing in the original affidavit that even addresses nursing. Now, to go back to Your Honor's
Let me ask one question, please. Sorry to interrupt, but
Yes, Your
we're
Honor.
we're not limited to her initial affidavit at this point, because
Your Honor.
that ship sailed because you couldn't do a second cert. We're here on summary judgment, de novo review, and we have a second affidavit from Dr. Venkat that clearly sets forth in paragraph 2 that she knows what the nurses are supposed to do and what they didn't do in paragraph 5, and clearly disagrees with Dr. Holland. So are you saying we're limited to just review of the initial affidavit?
Well, Judge Sleet, we're limited to whether plaintiffs pled a timely complaint the first time around, Because if that complaint shouldn't have been allowed to go forward, if it was not actionable because pre-suit wasn't complied with.
Well, but Judge
And-
Newton held that they did. And you rightly argued you could not do a second cert. Just because you disagree with her, she followed the law. She had an evidentiary hearing. So that ship has sailed.
Your
Are
Honor,
you telling us that we're going to ignore the second affidavit?
Your Honor, well, the answer to that is going back to the evidentiary hearing, plaintiff, that the hospital got its procedural protection, but that is an interlocutory order. The issue of whether Dr. Venkat was qualified in the first instance has never been adjudicated finally. So that's an open question. So now, if the complaint was not pleading a cause of action properly in the first instance, my answer is yes, Your Honor. We should not be looking at the second affidavit because it should have been dismissed in the first instance, number one. But there's something else that Judge Sleet, Your Honor, brought up that I want to address because I think it's very important, and maybe I'm addressing the other two judges, or I'm not sure. But as far as Judge Venkat's qualifications, the section 766-102 is very specific as to nurses. And it has language in there when a physician is testifying against nurses that it doesn't have anywhere else in the statute. And that is they have to be licensed in Florida.
Have you read the Roden case?
Your Honor,
Have
no,
you
we
read
read-
the Roden case?
no, Your Honor.
Okay, I'll cite it for you. 40 Southern 3rd 112. Roden clearly says the license provider referenced in section 766.102 subsection 5 does not encompass a universe limited to Florida licensees. If such medical expert is not a resident of the state, the division shall forward such report to the disciplining authority of the medical expert. So if the state of Florida has the authority to discipline an out-of-state expert, then that statute subsection 5 does not limit it to Florida physicians. It's clear.
Well, there's that language, Your Honor, I agree.
Hadn't been
is-
reversed,
but-
hadn't been aggravated.
Well, but we also, Your Honor, we have the Durja case from the first district. And so
Is there a
that,
conflict with Roden?
I believe if.
Do they declare a conflict?
No, Your Honor, well,
Okay, thanks.
Durja, I believe, came first. And since I can't talk to Roden,
Go ahead.
Kelly, well, I
Finish your answer. I can ask this at any time.
sure. Two things just to follow up with this, Judge Kelly. But one is the Durja case does say that that language means pre-suit is not even required against a doctor being sued in Florida who's out of state. Number two, the out of state license, the certification statute specifically says it's only to testify against physicians. So now we have two statutes. The legislature is aware of Durja when it puts this language in that say that 458 and 459 mean Florida physicians. So, that was the point I wanted to say. And Judge Kelly, I know you were about to ask me.
Yeah, I do have a question. You keep focusing on nurses. Is the reason you're focusing on nurses because you think that is the only route through which the hospital can be held liable?
No, Your Honor.
Okay, because you keep coming back to, well, the expert affidavit, she can't speak to the standard of care for nurses. Oh, I don't, okay, so what?
Well, no, and Your Honor, and I would cite to the court, Your Honor's decision in University of South Florida versus Mann. And that is,
when you
no.
do that.
Well, but it's significant because that Your Honor's held, or this court held, that if you don't describe the negligence in the affidavit against the hospital, then it really doesn't do anything against the hospital. It's not sufficient against the hospital. And so that's what I'm really going back to. I say nurses
Okay.
because plaintiff said it.
But unlike Mann, where there wasn't any averment or allegation of negligence against the nurse, Dr. Venkat's second affidavit clearly sets forth a violation by the nursing staff.
Yeah, I thought she pretty much got everybody
And I
including
want to
the
make,
hospital.
I want to get a word and then ask you a question about her qualifications under this statute. Your position, if I'm understanding correctly, and as I understand it through the briefs, was that under subsection 6 of 766-102, she's not qualified. And your Judge Sleet is telling you we may have case law that takes this out of that equation, but I'm not following all of that. So I would like you to address in as precisely as you can your position with respect to, as I understand it, that you're saying Venkat can't testify to the allied health providers, to the standard of care for this hospital, because she's not qualified under, or she's not licensed under 458 or 459. Am I so far correct?
Yes, Your Honor.
Okay. And is that the whole shooting match with her in respect of the allied health providers, the not Dr. Healy and the ER physicians?
It's only the shooting match as to her qualifications. And I only say that because we still say that it just wasn't verified or corroborated the first time around within the statute of limitations. So I don't want to lose that argument. When the complaint was filed, there was nothing to corroborate nurses, and she didn't identify anything in her affidavit at that time or in the complaint that a nurse did negligently. But the shooting match, as far as the qualification of Dr. Venkat, Your Honor, is yes, is exactly as you said it, that and the certification statute.
Okay. And so with respect to the amendment of the complaint, it follows then on your argument that she's outside the statute of limitations with respect, putting aside the qualifications because of the timeliness.
Well, that's correct, because the original complaint didn't corroborate any nursing negligence and didn't identify any nursing negligence, and went under the traditional vicarious liability theory against the hospital without any even identification in the affidavit of nursing, and putting her qualifications aside. Yes, it just wasn't identified.
But Florida recognizes corporate liability for a hospital.
Absolutely. But it also recognizes that a hospital cannot commit malpractice, and it can only act through its agents unless there's a limited.
Well, now maybe I'm misunderstanding your answer, but you know, there was case law in Florida that adopted this notion of corporate liability for a hospital for essentially medical malpractice, that the hospital, even though it doesn't quote practice medicine, could be liable independently, directly liable. And then that was later codified in a statute. I'm not recalling the number, but you know, there are direct liability, corporate liability cases against hospitals because they do have certain obligations, like for instance, to have an emergency room and to meet a certain standard care, to provide equipment. I mean, the statute lists a number codifies a number of the duties that were recognized in prior case law.
And Your Honor, I agree. I mean, and the case law recognizes non-delegable duties. It recognizes administrative, non-clinical negligence. There's no question, Your Honor, that I agree with you that direct claims can be brought. Our issue with that is that they weren't. There's no non-delegable duty claim that was ever pled or even made a record of in this case, so that's gone. The first time Dr. Venkat mentioned the non-clinical type claims, this negligent type having guidelines, was 7 years after the incident. So that was not either corroborated or pled the first time around. So I agree with Your Honor. There are such claims, but they just weren't pled the first time around. And that goes back to our whole problem with this, is that in 2016, when the complaint was filed, it was pure, just you're liable for the actions of your agents without any corroboration of the agents. I mean, it's really that simple. It comes back down to that. A stroke center doesn't practice medicine, agents do. If they want to bring a non-delegable duty claim against a stroke center, it's never been recognized, but I grant them the opportunity to at least try to make that argument, but it wasn't pled below, and there's no record saying what the statutes would be or if there's a contract, you know, et cetera. So again, you know, that's on them. But going back to the original complaint, I think it's a pure and simple issue of, you know, are you alleging that agents of the hospital were negligent? They were. You know, where's the corroboration? And plaintiff's stroke center theory is saying that as long as you say it's a stroke center without any non-delegable duty, everyone is swept in, and you don't have to corroborate nurses, you don't have to corroborate emergency room physicians, you don't even have to say what they did wrong. It's just a stroke center. And that's our issue with the stroke center theory, is that, you know, it's just not a theory. It's not something that's been recognized.
Well, just to be devil's advocate, you're the hospital and you're marketing yourself. And so you come up with this, we're going to be a stroke center, and there are guidelines. I mean, it's a real thing. There are guidelines and there are standards of care as to how it should operate.
Sure,
So-
yes.
So
Oh, yes.
you sell yourself to the public. Come here. You think you're having a stroke? This is the place to come. You don't think that creates some duty on the part of the hospital, whether it's delegable, non-delegable, but some duty on the part of the hospital to meet the appropriate standard of care for that type of what they've held themselves out to be.
That, I have no issue with that, Your Honor. What my issue with what Your Honor is saying is that that is a separate cause of action that needs to be pled, whether it's, you know, some advertising claim, some non-delegable duty claim. I don't take issue with at all with what Your Honor is saying, because, you know, we've seen those cases. But it has to be pled, and plaintiff made a choice in the beginning, even after the hospital kept writing to the plaintiff's counsel and saying, what agents were you saying were negligent? And that's in the record. They made a decision to just go forward on vicarious liability. And that's when the
Well-
statute of limitations.
Let me refer back to her original affidavit, being Dr. Venkat, paragraph 5I. In the middle of the paragraph, also incorrect values were assigned because the assessing nurse initials NNH did not know how to properly perform NIHSS assessment. Now, that, you know, originally she thought it was a nurse, but we come to find out that that was Dr. Healy. But isn't that putting the hospital on notice that the nurses breached the standard of care, whether it was Dr. Healy or a nurse or not?
The problem is, well, first of all, the hospital, it just created confusion, which is why the hospital wrote to the plaintiff and said, you know, please clarify this. And if you have any question about who the records refer to, highlight it and send it to us, and we'll tell you who that person is. But you know, if the hospital is looking at a form and it doesn't have any nurse on it, then I'd say, you know, no, not necessarily. And to
I don't know
follow
what
up on
else
that,
they can do other than give you the initials NNH. I mean, that's how your client decides to produce medical reports, is by initials, and they allow somebody to do that instead of requiring that they give their full name. What's the plaintiff to do?
Your Honor, the bottom of
NNH is there, and they tell you NNH, and they tell you they believe it's a nurse. So they believe a nurse is at fault or breached the standard of care. And then sometime later, because I don't know when the plaintiff found out that NNH was indeed a physician as opposed to a nurse, because you didn't disclose it in pre-suit. So I don't know.
the plaintiffs, I think I submit, I can't think for them, but they haven't pushed this issue because of the record. I mean, there was no hide the ball on the part of the hospital. But and if Your Honor, it's a one-page stroke assessment form, which has, it's signed by Dr. Healy. It says doctor clearly, and his name is printed at the bottom, MD. So there was no hide the ball here. But to that point, to that subparagraph, so it turns out, and now, you know, plaintiff knows that it's not a nurse and it's Dr. Healy. It goes back to the rest of the affidavit. Where's their corroboration against the nurse? Because we're certainly not going to go to trial and make everyone pretend that Dr. Healy's a nurse, because that's what plaintiff thought before. I mean, at the end of the day, they still have to prove that an emergency care physician was negligent on that point and not a nurse. There's nowhere else in this affidavit that talks about nursing negligence. I mean, she continuously talks about stroke center, neurologist standard of care and stroke center. And, again, we have to look at it at this point of time. I think it's critical because that's the statute of limitations. That's when the letters were going back and forth from the hospital. I mean, there was literally a letter that defense counsel, the hospital's counsel, sent to plaintiffs early in pre-suit that said, please identify every employer agent you're contending was negligent so we can decide whether you've complied with the pre-suit expert provisions. So there was no hide the ball. If there was any confusion, it wasn't on the hospital. And at the end of the day, we know who I is referring to, and it's not a nurse. And there's no other nurse referred to in this pre-suit or identified as being negligent. And
I'm sorry, I just want to let you know you've got about 30 seconds. So if you wanted to wrap up.
Certainly, Your Honor. And my recollection from the second affidavit is that it too, it might have, said I could talk about stroke centers, but it still didn't identify any action that a nurse took that was negligent and would involve nursing, standard of care, or that's even an issue. But, I go back to that. We look at the plain bright line time of when all this happened. If it wasn't timely and properly pled and corroborated in 2016, they can't bring it back to life in 2020 by moving to amend their complaint. It's too late. You can't bring back to life an untimely complaint 5 years later. So I would ask and submit that Your Honors affirm the summary judgment. There is no cause of action that's been pled or corroborated against the hospital. Thank you.
Thank you.
Counsel, I have a question to start off with, and I would grant you extra time, assuming that the presiding judge allows you to do that. But here's my question.
Depends on if I like your question.
Okay, well, you can tell me later. I don't know when you found out that NNH was indeed a medical doctor that required separate pre-suit notice. I don't know when. But we have to look at this denial of the amendment under abuse of discretion. And so it's clear that the trial judge understood that Dr. Healy was disclosed. Dr. Healy was deposed in August of 2018. You amended your complaint in April of 2020, about 18 months later. You and I know in Med-Mal that once you found out it was Dr. Healy, your 2-year statute of limitations could have started and you could have done a pre-suit notice on Healy. Whatever your strategy is, I'm not criticizing it, but you decided not to do that. So the trial judge understands that. Tell me how it's an abuse of discretion to deny your amendment at that time.
Well, because when the trial court focused on the fact that amendment was futile against Dr. Healy because the statute of limitations had run and we couldn't get an appropriate, affidavit from an emergency room physician as to Dr. Healy's standard of care.
I understand that, but once you found out it was Dr. Healy, you could have then done something about the nurses then too.
Your Honor, I can't answer that question. I don't know. I don't know.
Okay.
I don't know what the strategy was or what caused the delay. So I'm sorry. It was a very good question. But I don't have an answer.
Hear that, Judge Kelly? She said it was good.
I concur.
I was just going to tell Judge Kelly, I said, it was a good question, so you should give me extra time.
You got another minute
Thank you.
added to what you have.
Opposing counsel does agree that we should have amended our complaint to plead that it was okay to plead the non-delegable duty of the hospital. And that's exactly what we were trying to do in our motion for amend. So if they agree that amendment would be proper to assert the non-delegable duty of the hospital, that's another reason why amendment should have been.
Well, I'm
done.
not sure I heard her argument that way. I think what she was saying is you would have to do it. I don't think that that is an admission that you are able to do it.
Okay. But,
I don't want to
That's what we-
speak for her, but I'm pretty sure that that's,
well, we do agree, and I do
argument.
make an argument, I'll refer you to my brief, as far as amendment relates back to the original complaint. It's just that the amendment clarifies, specifically clarifies that it's Dr. Healy, not a nurse. And it clarifies that we have a non-delegable duty claim against the hospital, and which Dr. Venkat is qualified to give an opinion as to the standard of care for a stroke center, and therefore her affidavit as to the non-delegable duty was timely and not futile. The other thing is that, as Dr. Sleep pointed out, and that the first affidavit does mention the nurse. Unfortunately, it's the one with initials NNH, which then turned out to be Dr. Healy. But she does say, did not know how to properly perform an IHSS assessment, and improper performance violated the standard of care for stroke centers. So she's saying that the improper assessment is what violated the standard of care. So, and that was in the original affidavit, which now there's being made an argument that the second affidavit is untimely. I don't know that that argument has, I've heard that argument before, but I don't see that since they were going on this second affidavit, which was accepted by everyone, that she does then say she's familiar with the standard of care required for hospitals and hospital staff. And if you look at page 2 of my reply brief, that will list the her affidavit addresses the standard of care expected from a stroke center that she then says has been violated by the hospital holding themselves out as a stroke center. So I know I'm out of time, so I will ask you all to reverse summary judgment as to the nurses, because Dr. Venkat is qualified to testify as to the standard of care for nurses in the stroke center, and to please reverse the denial of the motion for leave to amend, because Dr. Venkat's affidavit, corroborating affidavit as to the hospital standard of care was timely, and amendment is not futile. And I thank you all
Thank
for
you.
your time.
Thank you. Thank you both. Interesting case. Thank you.
Thank you.